And now, if you've been following these videos in sequence, you know we have to be on to future interests. Because we already covered concurrent estates and present estates, the logical next topic is future interests. I was about to say that if you like this, put a like on the video and subscribe to the channel, and yeah, that still applies. But how about something old-fashioned? If this is helping you in your study of property, then tell anybody you know who's studying law that these videos are up here. I mean, literally, have a conversation. Tell them about it. On to future interests.
All right, future interests. Future interest is a non-possessory interest that's capable of becoming possessory at some time in the future. So we can have an interest in land, yet not have the present right to possess it. This is still a valuable interest. It means that at some time in the future, we may have the right to possess it. So that's a future interest. We've already discussed some of these.
So this really literally is an interest in real property.
That's right. And therefore, like any interest, would require writing to avoid the statute of frauds and so on. All right, future interests. Now we've already discussed the future interests that go with the grantor. These are the possibility of reverter, the right of entry, and reversion. Now we want to discuss those future interests that go to someone other than the grantor. In other words, some third party. And there are two main kinds of these. We've already discussed them briefly. There's your remainder, and there's your executory interest. Now, a remainder is a future interest that goes to someone other than the grantor, that becomes possessory upon the natural termination of the preceding estate. So it's natural termination. That's your life estate hypo. So to Nancy for life and then to her brother. All right, so her brother would have a remainder because Nancy will live out her life, and then upon the natural termination of her estate, her brother takes, as opposed to an executory interest, which cuts short a prior estate. So in your executory interest, we've already discussed, to Nancy, and we could say, but if she should ever leave the land for more than 6 months, then to Bill. And so Nancy's still alive, but she leaves for 6 months, and boom, Bill comes in, cutting short her estate. So that's your executory interest. That's the difference. Now let's focus on remainder for just a minute. So we have life estate to Nancy, then to her brother. And so this would be a remainder situation. First of all, Nancy's brother is one other than the grantor. So we know we're dealing with a future interest in someone other than the grantor. We know that as a remainder, brother will take over upon the natural termination of Nancy's life estate. Now, when it comes to remainder, we have to consider two main types of remainders. Remainders that are vested and remainders that are contingent. A remainder is vested if you can meet two elements. Number one, you need an ascertainable person. That means if I said to Nancy and then to her brother, if she had a living brother, fine, then her brother would be ascertainable. If I said to Nancy and then to her brother, and she had no brother, and there was just the hopes that she would have a brother at some time in the future, then brother would not be ascertainable. The other element you need, in addition to ascertainable person, is no condition precedent. So, for example, I could say to Nancy and then to her brother, if her brother reaches the age of 21. Well, in that case, let's assume her brother is ascertainable. Let's say he's alive, but he's only 8. Well, there's a condition precedent there, and that he can't take until he's 21, no matter what. And under those circumstances, you would fail to have a vested remainder. Now, it's good. You'd rather have a vested remainder, wouldn't you? Because if your remainder is vested, in a sense, you know pretty much you're going to take. There are some minor exceptions to this rule. I'm not going to actually go into them. They're discussed in our book. But very briefly, you may have something called indefeasibly vested, which means it cannot be divested at all. We have remainders that are vested but subject to what's called partial divestment. This occurs when we have a class gift to Nancy and then to all of her siblings. And let's say she has 3 living siblings, but there's the possibility that she may have another. Well, in that case, the 3 siblings, they're ascertainable, they're living. There's no particular condition here, but because it's given to a class, someone else may be born and become part of this class. So whereas as there's 3 children, each owns a third, if a 4th child is born as a sibling, then each owns a 4th, and there's this subject to partial divestment. You can also have a situation where you're subject to total divestment, and that's where we have what's called a condition subsequent. So I could say to John for life, then to Bill. But if Bill should ever leave the land, then to Jim. So Bill is ascertainable, and there's no condition precedent, there's a condition subsequent. It's subsequent because it occurs after Bill takes. So Bill's vested, and we know Bill's going to take. It's just that Bill could lose his interest if he acts in a certain way. And this is your remainder subject to total divestment because of a condition subsequent. All right, what about contingent remainders? In contingent remainders, well, basically you can't meet the elements of vested. So that means either there's not an ascertainable person, or there's a condition precedent. So for example, if we were to say to Nancy, then to her brother, and she has no living brothers, as indicated, there's no ascertainable person. And so therefore, whoever this brother is going to be has a contingent remainder. And as indicated, we could also have some condition precedent in there that he reaches the age of 21, in which case, again, he'd have a remainder, life estate to Nancy, then to her brother if he reaches the age of 21, or when he reaches the age of 21, doesn't matter. Well, he has the condition precedent that he has to live to be 21. Now, remember, if the remainder is vested, it's generally not subject to the rule against perpetuities. But a contingent remainder will always be subject to the rule against perpetuities. All right, finally, executory interests. We've discussed these. Let's finish this off. This is a future interest that cuts short a prior estate in favor of a third party. So remember, we have to have some third party name. If there's no third party name, then it's going to go back to the grantor. That makes it pretty easy, and it's a pretty clear distinction. Does it go back to the grantor? Does it go to a third party? Well, To have it go back to a third party, some third party must be mentioned in that conveyance. So it's fairly simple. And remember that your executory interests, as I indicated, are subject to the rule against perpetuities. Now we have some additional technical rules in our book. These are generally not tested on essay exams, but they are part of the multi-state bar exam. I'm going to leave it for you to read. And we also have a summary table which just basically lays out the present interest and future interest just for summary purposes. All right, let's just talk briefly about the rule against perpetuities. I wouldn't go crazy about this rule if I were you. One of the things I'd want to know is, where does it apply? Where doesn't it apply? Because if you know that, it puts you in the ballpark. Because if you get a question that says this interest fails because of the rule against perpetuities, and the interest is a future interest that goes back to the grantor, we know that the rule against perpetuities does not apply, and so therefore the interest will not fail because of the rule against perpetuities.
So that's a really quick way to eliminate some wrong answers on somebody's multiple choice.
Exactly, exactly. Now the other thing is we give some exemplars, in other words, examples that illustrate huge classes of possibilities that show you how to analyze the rule against perpetuities. Now in essays, I want to give you a suggestion. Do not use or headnote or write about the rule against perpetuities unless the rule against perpetuities either appears someplace in the fact pattern or the call of the question asks you to write about the rule against perpetuities. In other words, the call of question says, this fails because of the rule against perpetuities, discuss. Well, in that case, you're stuck. You have to discuss the rule against perpetuities, but only then. So what do you do?
For bar exams.
For bar exams.
For
That's
law
right.
school exams, if your professor has just taught you the rule against perpetuities, you might need to write about it anyway, but we're talking about bar exams.
Yeah, on bar exams, I wouldn't talk about it unless it was called or I saw the actual rule against perpetuities. On law essay exams, on law essay exams, you might have to write about it if you want to get the top grade in the class. Okay. All right, well, here's what I recommend. Let's say the rule against perpetuities is called or part of your hypo. Well, then headnote the rule against perpetuities. And then, and this is the toughest part, give the rule. Let's go over it. No interest is good unless it must vest. So either it has to vest or fail to vest, if at all, within 21 years after some life and being at the time of its creation. So basically what that's saying is the interest is either going to have to vest, you're going to have to prove it's going to vest, or you're going to have to prove it will fail to vest, at least within the span of some life in being at the time of its creation plus 21 years. And that's so difficult for so many people that what happened to the California Supreme Court when
I love this. The California Supreme Court literally ruled that it's not malpractice in the state of California for an attorney to mess up the rule against perpetuities because it's so difficult, so incomprehensible. So that tells you that in California, at least, you're not going to get a bar question where your passing score hinges on accuracy in the rule against perpetuities. They can't do that because the California Supreme Court has said it's not malpractice.
Well, your analysis can go either way and it won't matter. All right, now you can show some knowledge. You've headnoted it, so therefore you did not miss the issue and you're being responsive to the call of the question. You've given a good, clean rule. That's good. That'll get you some points. Now you must analyze. And where I would analyze would be two main points or subhead notes. First, life in being. And tell the bar examiners that the key is at the time of its creation. See, life in being at the time of its creation. So if it's created by a conveyance, then that life in being is triggered immediately. If it's created in a will, then we have to wait until the grantor, or testator in this case, dies, and then we look at all the people in the world who might be alive at that time. So that's at its creation. That tells you something right there. It's more easy for a conveyance to fail than it is for a devise and a will, because at the death of the testator, then you can look at that point, whereas at the conveyance you still have to consider the entire life of the testator or the conveyor. All right, so analyze life in being. Pick somebody relevant. In other words, pick one of the names of the people in your hypo, and you could pick the kids or you can pick the grandkids. Pick somebody who's alive at the time. And then your next subhead note would be, well, it has to vest or fail to vest. And there, use some facts and analyze whether you think that either this must vest during this individual's life plus 21 years, or it must fail to vest during this individual's life plus 21 years. And let's go through just one of our exemplars in our book. It's example number 2. Let's look at it. It says to A for life, then to B if B passes the bar. Well, will this fail due to the rule against perpetuities? Let's analyze. Let's look at the measuring life. Let's see, to A for life, then to B, if B passes the bar. Let's make B the measuring life. All right, what can happen? B can either pass the bar during B's lifetime, or B may never pass the bar during B's lifetime. In either case, this must vest or fail to vest during B's life. Therefore, it does not violate the rule against perpetuities. Let's look at another one. To A for life, then to B, if B goes to the moon. How about that one? Will that one fail? Let's analyze. B will we'll use B as the measuring life. B will either go to the moon or B won't go to the moon during B's life. Therefore, this does not fail under the rule against perpetuities because it must vest or fail to vest during a life in being, that's B's life. We don't even need those extra 21 years in this case. So you can see any of these. This is why we call it an exemplar. To A for life, then to B if B gets married. Will that succeed or fail? I'll let you analyze. To A for life, then to B if B gets rich. You analyze. And I recommend that you go through all of our hypos, and that'll teach you how to analyze the rule against perpetuities.